everyone, and thanks a lot for joining us today. We appreciate you coming, especially given how many of Ukrainian themed events there are this conference this year. We are going to be focusing today on the role of Ukraine and the international community in ensuring justice for the war in Ukraine. And we are going to look at this issue through many dimensions, which I will dive in just a second. But before that, I would just like to highlight that this event is organized by the Ukraine 5-Year Coalition, which all of the organizations who will be speaking today are members of, as well as we want to specifically highlight for the immense help that we got organizing and making this event happen, the Helsinki Foundation for Human Rights. With that being said, let me just briefly introduce our speakers and we will dive into the discussion. We will aim to, and we will have the Q&A or the discussion session at the end, so please get ready for that. My name is Arie Mora. I am a member of the Ukrainian Legal Advisory Group. This is mental focusing on justice and accountability in the context of armed conflict. We will also have several amazing speakers joining us today, which is, first of all, Romanov from the International Renaissance Foundation. We will also have Alena Lunova, advocacy director of the Human Rights Centre ZMINA, Lyubov Smachylo, which is the analyst of the Initiative for Human Rights, as well as Yedeliev, who is an associate professor of the Shevchenko National University of Kyiv. Now, just to briefly get us into the topic, and I will then pass on the mic to other speakers. The reason for us getting here today and the kind of the concept that we've been envisioning for this discussion is basically that while it has been more than a year and a half after the full-scale invasion, there's been an immense response by the international community and within Ukraine as well in order to ensure justice and accountability for the grave crimes that are being committed right now and that have been committed, unfortunately, throughout the war, starting from the 2014, but is of course gaining much more of a scale and scope since the February 24th. However, this response has several issues that we as civil society, as academia, as people who are involved in this work in general, have been noticing, which risk either undermining the pursuit of justice and accountability and protection of victims of these crimes, or could use some of the improvement and development that would increase its efficiency and make the impact much higher. And this brings us basically to the point where we believe strongly that in the context of Ukraine's situation in general, and specifically international community, states and organizations have a very strong role in making decisions happen, in imposing and enforcing policies, in directing navigating the way justice architecture for Ukraine and the world within the context of this conflict is being built up. And for that to be efficient and to be as impactful as possible, it is important to have a framed discussion about how those efforts are being implemented right now, what is missing, and what we could see more and do more to please join us to enhance those efforts and do better justice for the victims. We will start from the point of the domestic system because it seems like that, hi, please join. It seems like the domestic system in general is the starting point from ensuring justice and accountability. It has the main burden and the main obligation to ensure justice for the grave crimes. And of course, Ukraine has met this challenge, unprepared for very logical reasons. No one would expect this kind of challenge to face. This goes like in terms of many different aspects and issues. I will just quickly say that, of course, first of all, it goes with regards to the legislative framework, right, which has been not ideal up until today, and despite many efforts to harmonize domestic law with the international humanitarian law, with the international criminal law, it's still missing a lot of important norms to make the investigation of these crimes, the classification of these crimes, as well as the trial itself, in accordance and in compliance with international standards of due process, in accordance with international law in general. This, of course, goes beyond just the legislation, because both the legislation but also the procedure itself severely impacts the work and the efficiency of the work of the justice system representatives, the investigators, the prosecutors, judges, and the defense counsels as well, which we will touch upon just a bit later, who unfortunately still lack resource, capacity, as well as knowledge and expertise in terms of how to deal with international crimes, because those are sufficiently different from the ordinary crimes, and this distinction has not been yet fully clear for some of the stakeholders involved in the process, and therefore all of it needs for A, actually seeing those problems and those issues, but B, specific and appropriate response towards those challenges, which we will touch upon in a bit. But in order to go further and dive into this issue within the domestic system, I would like to pass on the floor to Alena Lunova. The floor is yours. Thank you.
Thank you, Arie. Probably we all will have a short intervention, and my intervention will be about prioritization and priorities in the criminal investigation. This is really complicated and controversial issues because somebody needs to know what crimes need to be investigated in the first place, but how we can decide, how we can compare war crimes and such amount war crimes, because right now we have almost 110,000 documented war crimes according to OPG office. And this is the issue for each legal system in the world, not just for Ukrainian legal system. But to truly understand that effective investigation of all those crimes on the high level, it's impossible by default. In this situation, we need to say about prioritization, but we see that the investigators in Ukraine do not have such. And this is the issue of our future and demand of justice by Ukrainian society. And Ukrainian society demand justice in war crimes and also in domestic crimes, such as crimes against national security. And I want to provide some example in this sphere, because after the beginning of the full-scale invasion, in Ukrainian criminal code appeared the article 111-1, which is about collaboration activities. And actually it's about cooperation with the occupied authorities. The first target of this article is those who are living on the liberated areas and those territories which are under occupation of the Russian authorities. And we see that those crimes against national security, we have almost 16,000, and more than 6,000 of that, it's a collaboration action. And we have almost 700 verdicts in these cases. And ZMINA is really precisely analyzed the verdicts, and we see that more than 75% of these verdicts is a verdicts literally about the likes in Facebook or YouTube or whatever. And we see that resources of SBU, our security service of Ukraine, who are responsible for investigation of the war crimes also, it really works not in line with the international law, and also we see that these resources are really spread in the cases in which it shouldn't be. Because we have really low level of resources for investigation, but we shouldn't use these resources incorrectly, use these resources for some women on the occupied territories who passed some, who gave some meat to the soldiers of Russian Federation. And we need to count our resources. So that's why prioritization should be one of the way how we can count our resources and how we can count resources of investigators and also of the prosecutors, because also prosecutors and courts are involved in the investigation process and process of justice. And we need to create the situation in which those resources need to be spread really wisely. And right now we have some strategy of the Office of the General Prosecutor, but we do not see how this prioritization will work in the situation of investigation of international crimes.
Thank you so much. Indeed, this is the question of identifying and seeing specifically on how within those procedures with this type of crimes, the justice system's representatives are being overburdened and unable to meet the results they're being expected for. However, the system itself does not necessarily provide the direction which could have optimized their efforts and could have increased their capacity. And this is something that we need to rigorously assess and address towards Ukrainian officials as well as in general society and community that is involved in justice. To continue this particular conversation, I would like to invite Lyubov. Please, the floor is yours.
Yes, thank you. Journalists from our organization, Media Initiative for Human Rights, they attend trials and closely monitor criminal proceeding concerning international crimes committed in connection with Russian aggression. In this context, we can talk about several difficulties of our national system. First of all, because our courts are overloaded, and as my colleague said, that we have more than 100,000 of instances of war crimes, and we understand that the number of instances play a role on the time and the quality of the investigation. We see now that verdicts are being issued unusually quickly, and another problem is that these trials are in absentia. It means that a trial is conducted in the absence of the suspect or accused person, and in this specific procedure we should take into consideration the situation of both parties, the suspect person and also the victim. First of all, we need to be sure that the suspect or accused person is informed in a proper way about the trial. Another thing that the suspect should be represented by the attorney. With this, we don't have problem because, formally speaking, the right of the defense was upheld in 100% of analyzed cases. But we understand that there is pressure from the Ukrainian society on attorneys, on judges, on prosecutors, because Ukrainians want to have a result. They want all perpetrators to be condemned, and in this specific situation we have this pressure of Ukrainian society, and from another side we have a victim, and we should have this victim-centered approach, and to understand that victims, they want to see a real person condemned for a real crime and to be imprisoned for the crime committed. And we have a complex mechanism of verdict enforcement when we are speaking about trial in absentia.
Thank you so much, and especially thank you to both of you so far for such concise remarks, which I'm not the best at. But indeed, this is particularly a very clear example, which are the proceedings that are taking place right now, starting from this very infamous, rather to say, Shevchenko case, which has highlighted numerous issues with the criminal proceedings, and unfortunately those have continued to be illustrated throughout the proceedings further on. And the question is that we will, at this point, move from the domestic system further on. And the reason is not because we have outlined all the issues that are present with the domestic justice system, but rather that it will take too much time for us to actually talk about all of them. But the main issue is that year and a half after the full-scale invasion, we really need to start getting much more of a focused approach towards the most acute issues that the justice system faces with regards to what do we want to address, which kind of help, training, resources we want to give as states, as organizations, as experts who are joining various efforts in improving domestic system. And to that, we really need to properly and realistically assess in which state the current system is. And unfortunately, sometimes the voices that our state parties here are not, or the ideas that they're being told are not the full picture. For many various reasons, it's quite understandable, but the main message here is that we need the stakeholders who provide this assistance to go one step further, to ask one more question, to talk to one more person, to really consider what the reality is. And this is imperative for the relevant and actually impactful help to be addressed and impulsed towards the system in Ukraine. Now moving on towards the in more of an international response to in terms of the conflict in Ukraine, the war in Ukraine. I would probably suggest starting with the universal jurisdiction and relevant respective efforts, and to that end I would like to invite Roman. Please.
Yeah. Thank you, Arie, very much. Really, so we have three pillars of conflict-related justice. Yeah, it is national system, national systems of other states, and international criminal court. You have just heard some problems that we have in the Ukrainian national system, but what can we say about problems with universal jurisdiction exercise by other states? When numerous states supporting Ukraine initiated criminal proceedings using universal jurisdiction, they demonstrated their strong support for Ukraine and addressed the call for justice by their societies. Nevertheless, this political issue, universal jurisdiction, remains a legal tool of criminal law. So now we need to consider what each state hopes to achieve by using its universal jurisdiction. Would it be enough if the Ukrainian court finds the person guilty, or the Russian one in a new democratic Russia, or the international court? Or is it necessary for the offender to face trial in a court of that state? One may say that potential appropriate achievement of the universal jurisdiction is cooperation, such as through joint investigation teams. Currently, such collaborations have demonstrated effectiveness. But was the use of universal jurisdiction necessary to establish such cooperation? It appears not, as cooperation in criminal investigations can occur without it. Thus, what precisely does universal jurisdiction provide? The answer to this question is important for further implementation of the universal jurisdiction mechanism. Can universal jurisdiction guarantee justice in a case of an international armed conflict? Currently, there is still no clear answer. Or we are just afraid to answer that no. Universal jurisdiction is just a supplementary mechanism to establish some cooperation between prosecution offices or investigators. But that's all what can universal jurisdiction propose. And it is a serious problem, because you understand that we have quite a lot of new conflicts, and the issue of universal jurisdiction goes far beyond the Russia-Ukraine war. And the third pillar is the ICC, and I'll start some discussion on this point, and then Roman will continue it. But my idea is that we really need some sustainability in this conflict-related justice. Because we know that conflict-related justice takes years, possibly even decades. Thus, it is crucial to maintain this stability, as all progress made can be undone with just a single decision. And to achieve this aim of sustainability, we must utilize international legal instruments. Ukraine is currently cooperating with the ICC in an extremely efficient manner. The ICC has never experienced such an extent of cooperation from any other, even state party, to the Rome Statute. Obviously, there are practical consequences of Ukraine's non-ratification of the Rome Statute. However, these consequences pose more issues for Ukraine itself than for the international justice system, which now has another chance to try to prove its effectiveness. For instance, let us consider a scenario in which a future government of Ukraine, and in any case once will have it, decides to terminate its exceptional level of collaboration. While the reasons could vary, we will not delve into them at this point. If you believe there are no such reasons for the termination of cooperation, consider that the government is currently finding justification to not ratify the Rome Statute. And the president has reasons for not signing the adopted law that amends the Criminal Code of Ukraine to ensure the proper implementation of international criminal law. So we may have the termination of this cooperation, while the Verkhovna Rada of Ukraine has made statements acknowledging the jurisdiction of the ICC. The ICC and the international community are limited in their actions in this situation. What can they do in this case? I am afraid that not much. And in any case, the answer to this question is not obvious. Therefore, to avoid potential issues, it is crucial to take action now and to encourage Ukraine to ratify the Rome Statute. Doing so will represent a step forward in promoting the sustainability of conflict-related justice.
Thank you so much, Roman. And indeed, I think we will get deeper into the ICC discussion, but before that, just getting back to the point of the universal jurisdiction, it feels like we all have high hopes for its application, especially given the unprecedented response and the number of investigations opened in so many countries. But it all comes down to what comes next after the opening of the investigation, right? And we do know, and it's understandable, that not all of the countries that have opened the investigation have the experience with dealing with such cases, like with UJ, right? We do have countries that have substantial experience in it, such as Germany or France, but also some others that haven't met this kind of challenge before. And while it can be gained, this should be considered when we actually utilize this practice and this instrument, right? And just opening the structural investigation and collecting evidence is only useful up until some point. And if that's the end goal, right, to just open the structural investigation and collect the evidence to further on pass it to the ICC, sure, that's fine, but just be frank about it. And we should realize what kind of perspective and potential do we have. If we hope for more from the universal jurisdiction, because some of the organizations of the Ukraine 5 Coalition, including ours, is using UJ to protect the interests and defend the interests of victims of grave crimes. We already are meeting some of the challenges of this and limitations of this practice. We need to be frank and consider how far can we go and what is needed to go further and to achieve justice using this mechanism. But then, I think we can come back to the point of the ICC and see what are the further issues, but also beyond the ICC in terms of the international justice architecture. I would like to pass on the floor to Roman. The floor is yours.
Thank you, Arie. Actually, thank you for 5 AM Coalition for just inviting me to join this panel. So actually, I've been attending a number of events on Ukraine during different international forums for 1.5 years or even broader since 2014. And I think that there is a kind of overwhelming question whether Ukrainians have the end in all this list of their asks and asks, what do they want more and more from this partnership, from international community, etc. And just having this idea in mind, actually my organization decided to try to establish something what would be a kind of consolidated vision of Ukrainian human rights community about the most important issues on accountability. And actually we made that in a quite a successful way, and I'm just happy to introduce you the key points of the document, which is available online and which is signed by the broad community of Ukrainian human rights groups. It calls the Shared Guiding Principles on Accountability for Grave Crimes Committed in Ukraine. And it consists of 12 key points, so it's not endless. And I think that all of them are equally important. Of course, I don't have time enough just to introduce it, to dive deeper into all of them, but just will try to highlight some of them, which in my opinion are extremely important. And I just invite you to look at the website, which is rights, justice, peace.in.ukraine.ua, and you will find that in different languages, not only in Ukrainian, English, but also French, Spanish, Arabic. So, and one of the idea actually is trying to communicate from the Ukrainian human rights community, not only as a community which represents victims of certain country situation of certain grave crimes, but actually being a responsible part of international community who has certain shared principles about justice and who are willing actually to make a significant contribution. So each conflict, and especially if it's such a large conflict as we do have now, and it's like the largest war since the Second World War in Europe, should lead not only to this disastrous outcome, what is unfortunately unavoidable, but also to certain progress in understanding how to address those challenges in the future, how we can just not repeat all those mistakes which we made, how we increase the efficiency of the infrastructure for justice, peace, which is not functional as we can see, especially being a part of Ukrainian community and suffering from that every day. And I think that the most important is the language we use and the position, actually, how we try to do this communication. So it's not a big surprise that #1 principle is that Rome Statute finally has to be ratified by Ukraine. And it's not about like whether Ukraine is cooperating enough or not. That's really about principles. Whether Ukraine is a part of community which believes that all those grave crimes need to lead towards accountability or not, and being aside and trying to establish the separate tracks on relationships, which are quite manipulative sometimes, because like if you see the legislation of complementarity, etc., it's all based on the crimes committed by one side. What is quite justifiable from the point of interest of the Ukrainian state, but I don't think that as the responsible members of the international community, we can accept that, because like other countries can follow that. Why not? That's something what might be in the interest of concrete government, but not always in the interest of justice. Of course, it's not the way how we expect the ICC should operate. Also, there is a very important issue of resources. We know that this is unprecedented step from different countries that they offered support for the work of the OTP at ICC, but most of those resources available as a voluntary contributions for concrete situation in Ukraine. What creates, some conflicts between the victims of different conflicts, because for certain conflicts, countries are willing to contribute financially. For others, due to the lack of resources, the ICC can very, very limited opportunities. And the way how the OTP is trying to run away from these inconvenient questions, they just changed the way how they strategize their priorities. So instead of allocating resources to each country's situations, they now allocate resources to the legal issues they want to address. Of course, it's clear now that they can open the field office in Kyiv, and they cannot do the same in Ramallah, for example. So, I do not share the approach from Amnesty International, for example, criticizing that it's not equally dispersed. It should not be equally dispersed. But it should be clearly communicated with the victims of different conflicts, what are the priorities are, and what sort of expectations could be reasonable from the work of the ICC. And we believe that it's important to have significant core funding for the ICC, not through the voluntary contributions, not to the concrete situations. And even from the Ukrainian perspective, since all these funds came from 2022, the ICC is very reluctant to look retrospectively to the situations from 2014. All our organizations contributed a lot to the preliminary examination from the ICC. It led to the great report, but no steps, nothing else. And now, I think that this lack of core funding is quite a significant issue for justice, including the victims of Ukraine. I also wanted to highlight the issue with the European Court of Human Rights, which again addressed at this shared guiding principles. So then Russia was kicked off from this organization. They believed, of course, they left themselves, but in reality they were expelled from the Council of Europe. But then the decision was that for next 6 months, the ICC, the European Court of Human Rights, can accept the complaints versus Russia. Russia never agreed to that, and they believed that they left much earlier the European Court of Human Rights, and it has no jurisdiction. What does it mean? Does it mean that the concrete mechanism which we are aware of on the enforcement of any sort of judgments from the European Court of Human Rights would not work in that case? Because the Council of Europe, the Committee of Ministers of the Council of Europe, that would be problematic to enforce those judgments, because Russia would never consent on that. But I think this is the responsibility of the Council of Europe and all their member states, because they created a kind of expectations from the Ukrainian victims. And if we know from the very beginning that there is no way how to enforce those judgments, then we should think about extraordinary way how to address these needs. Otherwise, that would be just quite a losing situation, even offering some extra time, some extra opportunities in favor of the Ukrainian victims. And this issue is very much relevant to another one, which is about the reparations and the compensations. Since the Council of Europe is supposed to be the organization who the holder of this register, probably the solution could be somewhere around the frozen assets, the way how the judgments could be enforced, not voluntarily, but by Russian Federation, but in sort of other ways. So all those issues we've been trying to address, and the part of the guiding principles, we're actually working on the position papers which are diving deeper into each of that problematic issue, and I'm just encouraging you just to follow that and share and actually join some of those documents if you would be interested in. And I'll stop here and hope to have further discussion. Thanks.
Thank you so much. Now, before we move on to some of the, let's say, concluding remarks and then the QA session, which we actually still have time for, I would like to ask the panelists, maybe Alena, Lyubov, or Roman, if you have any comments or questions with the, or statements that you also want to make at this moment, maybe to add to the issues that we've discussed beyond your interventions. If not, that's completely fine. We'll just move to the further stages. Yep. Okay. Sure. Yeah. Go ahead. That wasn't like the way I intended, but that's all right. That's all right.
That's sorry. From my side, this is quite looks quite manipulative, but I will try to reflect on one important issue, which is always being discussed on such a forums, on justice related to Ukraine, which is a crime of aggression, right? So I think that there is enormous mobilization of political will and resources, first of all, intellectual so far, to find a solution. Of course, it's not normal situation. Then we have the UN Charter, which does not allow aggression, one country against other, to be happening, but at the same time, we have nothing to offer in the situation if it happens. I think we are in quite a unique situation, then we can have certain progress. But at the same time, again, I think that this issue is very much linked to the ratification of the Rome Statute, because there are, so what we need is a sort of mechanism which could be interpreted as an international court to overcome the immunities of Russian leaders. Otherwise, there is no sense to establish something really new. Because like in Ukrainian jurisdiction, we have lots of trials of the crime of aggression. It's even not a leadership crime. So like, I would be hundreds or thousands of court verdicts, but it's not something what we are, of course, looking for the crime of aggression. And there are two ways. One is just to join the community who believes that this crime has to be punishable, and to communicate at the level of values and to have them shared. For that reason, to join the family of the countries, and they are all united by their own statute and Kampala amendments. Or the second solution, to find the proper balance among the interests of different states who can support us exclusively in this concrete situation. And unfortunately, Ukraine officially made a choice number 2. And I'm not sure this is the right way, actually, how we can achieve the progress we are looking for. It's never too late, of course. Both options are available, and both ways, they are not exclude each other. But I think that much bigger progress could be achieved if it's consolidated. And we all understand that an ad hoc solution is unavoidable at this moment, but it should not, this step should not serve only the Ukrainian exclusive interest, but has to develop the international community and the justice system as a whole. Thanks.
Exactly. I think that this is the general overarching, the framing that we want to provide and suggest, which is that given how much of an interest and attention Ukraine's situation got, which is quite understandable, and as Ukrainian citizens we are very much thankful for, it does, however, basically creates a responsibility, an obligation for all of these responses to end up in strengthening and furthering the international system as a whole, not just for Ukraine, but for the world, for other conflicts and situations in the world. But this is definitely contingent on those efforts being effective, relevant, and well thought through, because otherwise they will neither work nor become an example like maybe just a lesson learned on how not to do, which I wouldn't really want to bet on, to be quite honest, given how many of those lessons learned we already have. But that also brings us to the point that it kind of is important for Ukraine to become more of a proactive stakeholder in those processes, and this is something that we are advocating for internally, but also, unfortunately, at this point, we need the support of international stakeholders to push Ukraine to become more of an active stakeholder rather than just a recipient of all of those efforts and all of those initiatives. This goes, this includes the Rome Statute ratification, this includes the actual cooperation with the court, which is exactly, it is happening right now, but without ratification, for example. Ukrainian authorities can include the amendment to the criminal legislation stating that this action of cooperation with the court only applies to those who are committing actions like on the side of furthering the Russian aggression, which basically says only those who commit the crimes on the Russian side are like within the scope of this section. It will not, if you are interested in this particular section, I can like give you the link later on. But it, of course, does not limit the court in its actions, but it clearly signifies and indicates the issue, which is that until ratification happens, there are many ways to try to work around the system and try to manipulate with it, which is something that we as the society would definitely not want to. And this brings us to the general understanding, which is those are all elements of the justice architecture in general, right? And it is important for us to stop looking at each particular section as in vacuum. We need to consider all of those as a comprehensive, holistic system. The domestic justice system has its own issues and its own role to play, which is quite a significant role. But the ways it can be supported is through other mechanisms. It should be complemented, and this is what the ICC is for, right? It is to complement the domestic justice system efforts. However, we don't see that much of a robust scrutiny with regards to understanding and assessing how far Ukraine actually fulfills its role in the complementarity principle of the ICC. And while we understand that the court itself might be reluctant to go too much further because they don't want to risk the cooperation, we want the countries and the organizations to be proactive in assessing and challenging Ukraine's capacity to do its part in ensuring justice for the war in Ukraine. This goes also with regards to the general understanding, as Roman said, when it comes to the special ad hoc mechanisms, which are probably going to be needed for Ukraine. But the question is, how do we approach this question? And it does seem like we approach it from the basis of politics, from the basis of optics, such as like which will look good and what would make us feel like the victors of the situation. We think that the search for the solution should be needs-based. It should be based on what the system needs, what it lacks right now. And for that, we need to assess. We need to assess those needs, what is lacking, and what are the best ways to approach and address those needs. For example, one of the possible ways is the ad hoc mechanism, but the one that would actually consider all grave crimes rather than just the crime of aggression. Should it be international, or should it be, for example, a hybrid, in order to strengthen the domestic capacity through the cooperation between the domestic judges and investigators and international judges and investigators, such as in the case of Bosnia and Herzegovina. There are many discussions to be held in terms of particular solutions, but the question is, what are the principles and basic standing, which we are starting those discussions, and we hope that this conversation provides a bit of a glimpse in terms of how this can be approached. So in general, and then I will pass the floor to you, the framing that we want to kind of deliver is not asking for giving more to Ukraine just for the sake of giving more to Ukraine, but rather to sometimes we ask to push for some uncomfortable decisions, to push for the decisions that will actually be victim-centered and consider for the long-term development of the justice system for Ukraine and beyond. At this point, we have 10 minutes, or even just a tiny bit more, to discuss any questions or inquiries. that you might have. I can see one hand, and the way we will do it is I will pass 2 mics, and I can see the second one as well. You can ask the questions, but then I'll probably ask you to just pass the mics further on, if that's okay. Just give me 1 second.
Thank you very much. Olena Lunova, Right to Protection. First of all, thank you for drawing attention to such urgent topic, and moreover, thank you very much for giving insights broadly and considering the long-term decisions not only for Ukraine but for all conflicts worldwide. So my question would be probably to all panelists or who would like to address them. We all know that there is quite a lot of skepticism around the efficiency of International Criminal Court because of the quite a lot of resources that need to be used in order to render verdicts against one particular accused person. I mean about money, time, and investigation. So, if not International Criminal Court, are you considering any other options for Ukraine for war crimes committed in Ukraine? And if not, maybe what would you propose? How to improve the procedure in International Criminal Court in order for it to be more efficient? Thank you.
Thank you so much. We will collect the questions and then provide. Sorry. We will collect the questions and then provide the answers, if that's okay. So please.
Hi, I'm Alena. I represent the government of the Netherlands. Thank you very much for your presentation and also the thinking of how we can use the situation in Ukraine to work on a better system for accountability. I have 2 questions. One, when we're talking about universal jurisdiction, are you talking to different public prosecutors' office? Is there an international coordination mechanism already? And the second question I have is in relation to the in absentia and the victim-centered approach, because if that is still the case that we're working with, I feel strongly that it's still very important to keep processing these cases and to keep working on it, even if it's just in the case that in 10 years there's maybe not a war anymore, and we already have the statement and they can be put to prison. But is there something that we can do already earlier, or yeah?
Thank you so much. Do we have any other questions? I'll pass on them up. I see no hands so far, so we'll. Oh, yeah, please go ahead.
Thank you very much. My name is Anna, and I'm a lawyer as well, international lawyer. I'm Ukrainian. So I have 2 questions, one for Alena and one for Lyubov. The question to Alena is about case prioritization. You mentioned how important it is, and I know the situation from the point of view of Ukrainian criminal justice actors. I know that they do have case prioritization. And moreover, as in my previous role when I worked in Ukraine, we did case reviews, and we worked as a part of Atrocity Crimes Advisory Group together with the Office of Prosecutor General. So I was wondering if ZMINA made some kind of a research into the subject, something for me to read and to see how maybe this works not in all regions of Ukraine. And the question to Lyubov, thank you very much for addressing the question of fair trial and the question of defense lawyers and defense attorneys. It is extremely important. And so I wanted to ask you about, because we all know what happened to Shevchenko. We know that these people are getting exchanged afterwards. Do you think it is the correct way for resource allocations of the court, of prosecutors, of investigators, and maybe this is just a waste of resources? Thank you.
Thank you. I think we can move on to the answers, and then if we still have time, we can get some more, but probably we'll continue on the individual basis, if that's okay. So, starting from the... just for the mic to be there. But starting from the first question, if that's okay, I think just so that we're not actually, so that we don't forget it. Does any of the speakers, I assume Roman, wants to answer that, please?
Yeah, so the first part of the question is about the efficiency of the ICC. So if you look at the shared guiding principles, we actually welcome so far the approach towards setting the priorities by the ICC, concrete investigation of Ukraine. So this, the case on abduction of children, I think, is very, very important. And we believe that there is a way to extend the focus from just narrow forced deportation, much broader, potentially crime against humanity, but there's lots of ongoing work, and we can see already quite an outcome from the arrest warrant. You all have seen these pictures from Johannesburg, and 4 liters of bricks were there, and just the TV screen with Putin, just because of the arrest warrant. And it was a very friendly environment. Then this leader of Russian state wanted to be the most at that moment, and he could not make it. So I think that from that perspective, we can see already that it's very workable approach towards this concrete perpetrator. I do have some expectations that on several big and important cases, the ICC might do very efficient work. We all are looking for attacks on civilian infrastructure, systemic torture, and many other areas that potentially the ICC could step in, and I think that that's one side. But another side of this story is that from the global justice perspective, we have already enormous consolidation of resources from different countries put through this work of the ICC. Secondly, we have, again, it was very doubtful whether the South Africa would cooperate or not, but they did, right? And the most important, even with the United States, they finally came to the conclusion that intelligence data can be shared with the ICC. What is enormous progress, I believe, from that perspective. But we have, unfortunately, another sign, which is not a success. Then the UN official Victoria Gamba came to Russia, met officially with the person who's under arrest warrant, Lyubov. They were talking about certain plan towards the Ukrainian abducted children, and this is in the frame then, the UN has the agreement with the ICC. This is enormously, I think, destructive and irresponsible. So we all have the ways to ensure that the efficiency is growing, and it's not only about having the proper adjudication at certain period of time. That's much wider and more consistent. Thanks.
Thank you, Roman. Roman, now if you would like to.
I have just 1 minute. So I totally agree with your thoughts on international law reform, but I'm afraid that international law is more stable in its current way of work or not work. Being international lawyer, I'm not sure that all your ideas will work, and in any case, international law is complementary in this sphere, and we should pay much more attention to national jurisdictions. And of course, crime of aggression, we have a mechanism, we have the Security Council. The Security Council doesn't work, it is not a problem of the mechanism. It is a problem of the Security Council, you see? And if you propose new mechanism, there is no any guarantee that this mechanism will work. So, telling the truth, I'm a little afraid with such big reforms. And the question about universal jurisdiction. So, in a few European states, in Lithuania, Latvia, Germany, Poland, I guess, they opened criminal investigations In the Netherlands, I guess you have a bigger problem with MIH17, but it is not universal jurisdiction, it is a personal jurisdiction of victims, yeah? But how many problems you had with this case? And you see that from a legal point of view, I've heard a lot of discussions, but it is about people, Dutch people who died. And in the case of universal jurisdiction, there is much less connection. And what to do with it? To imagine court proceedings on these people, not sure in it. Thank you.
That's got quite heated, so Alena.
I'm not jumping into this discussion, but probably we'll try to answer the question which was addressed to me. ZMINA works with different kind of war crimes, but as I said, we precisely work with the other part of demanding of the Ukrainian side to justice, with the national domestic crimes of collaboration, of the cooperation with the occupied authorities, and we see that we do not have prioritization according to the verdicts, because Ukrainian law enforcement work with those cases which are really easy to investigate and easy to put into the court. It's about agreement in the criminal investigation and also in absentia. But we do not see how this prioritization, if it is, works during these cases, in these cases. And also, this is a perception from the civil societies. Yes, we have known about the strategy of OPG, about the investigation of the international crimes, but right now we see the raising numbers, and numbers is really shocked. And this is, how it could be perceived in the society, that the issue of OPG office is the numbers, but not, so we do not see the evaluation and the some actually, some cases inside these numbers. And this is the issue of perception also about justice, perception of justice inside the Ukrainian society, that Ukrainian society do not see the justice. And this creates real problem for expectations, and for expectation from juridical system of Ukraine. And I believe that this is a problem not just for civil society organization, but it's a problem for justice system. If we do not see the priorities, that's a problem of communication and also of OPG office and their work in these cases.
Thank you so much, Lyubov, and that will conclude.
Yes, so about in absentia trials, I don't think that it's a waste of time and resources for sure, and it's important, but I think that we have our internal problems of this procedure. First of all, starting from the how we inform the accused person, if it's in a proper way or not, if this person is aware about the trial is happening. So I think we can, it's our, on a national level, we need to do work on this. And about the execution of the sentences, I think we need here an international cooperation and of course another thing is a universal jurisdiction that can be helpful also.
Thank you so much. And indeed, I think that with the in absentia trials, it's kind of an issue of how it's applied and whether it's considered as basically a leeway to just further on the justice and the verdicts, to say that we have done our job, while the proceedings themselves are kind of could have been a tiny bit better, and the fact that you can proceed without the person perpetuates the issues with the justice, such as lack of witness testimonies, lack of actual thorough consideration of the case, and some other things. As well as with the prioritization, I feel like exactly while there might be some sense of priority, and probably it is also unfortunately or fortunately very much aligned with what ICC is doing, right? That's kind of, or what is popular at this moment, which I might be wrong because I haven't spoken specifically to General Prosecutor Kostin on this matter, but I would say that what we are lacking, and this is also reflected in the new strategy published by the OPG, which is they're still looking forward to prioritizing. This is one of their goals, and this is a strategy that has been developing for several months, and yet there is no clear strategy on what are the cases. So I feel like it's still an open question in terms of how far the prioritization is clear, but also how far there is a clarity in terms of what are the priorities, not just for the Prosecutor's General Office, but for the system as a whole, and particularly for the regions and for all the stakeholders. So I feel like there's definitely some stuff to discuss further on, but it's definitely important to consider we're not standing here and coming to Warsaw, to just say bad things about our government because we don't like them, we're striving to be not that kind of civil society, We're doing that in order to improve the system. All of us work together with many of the representatives of the state and this government itself. We train them, consult them, we ask them questions and come to the meetings to find solutions. But sometimes it needs a bit more of a push, and the international community organizations and experts are critical in making this better. And it's important for them to have as clear of an eye on the situation as possible, and we hope that this event facilitated and brought us closer to this goal. I guess we kind of need to wrap up, so thank you so much for attending this event. If you have any questions, please approach us. We are still here in the corridors and at this event. Thank you so much and have a good day.